Hello to all of our listeners and welcome to another Newsflash episode of Unpacking the Case. Today I am joined by Richard Snape, our Head of Legal Training here at DJB, who will talk me through the recent decision of Poundland Ltd and Toplain Ltd given from the County Court on the 2nd of July. Morning Richard, how are you?
I'm fine, thanks, Hannah. Long time no see.
We do seem to record a lot of these news flashes. There's a lot going on in the real estate law world at the moment, isn't there?
There's got a lot of case law because with everything else last year, a lot of the case law was sort of put on hold. So suddenly, since about April, there's been a whole influx of cases, commercial lease cases primarily, yeah.
And today we will be discussing a county court decision that came through on the 2nd of July of Poundland and Toplain. Can you please talk me through that decision?
Yeah, well, I'll give you the background because it's again something I've mentioned in a podcast, the basic idea, not the case, but a podcast and a Zoom conference back in June. It's about lease renewal terms, and it's a sort of post-COVID lockdown and the likes case on changing the terms on renewal, and specifically the fact that unlike in the past, leases now new leases being negotiated, the tenants want a clause allowing the rent to be suspended, not just in relation to damage and destruction of the premises, but in relation to pandemics as well, which wasn't normally the case in the past. There'd been a case in the past called Commerce Real Investment, Gesellschaft, and TFS Stores, which was from April of this year, which had made it quite clear that unless there was clear wording, the average rent suspension provisions wouldn't include pandemics. Yeah, there'd been another case from the same shopping centre, the Westfield Centre in Shepherd's Bush in London, involving Commerce Real Investment, WH Smiths and Commerce, where the tenants had wanted a county court decision, so it's not legally binding. And I was mentioning this in the past, where the tenants on a lease renewal under the 54 Landlord and Tenant Act wanted to include a rent suspension provision in the event of pandemic when it wasn't in the original lease. The landlord was prepared to accept a provision whereby if the lease of the premises themselves had to be shut down, the rent would be halved. The tenant wanted a provision whereby if any shop had to be shut down by statute or statutory instrument or advice or guidance from government, any shop in this huge centre, then the rent would be suspended completely and the service charge liability would be halved. And that was the original case, the case I was mentioning back in June in courses and podcasts. The law basically is based on Section 35 of the Landlord and Tenant Act is the relevant provision, which says that in deciding the renewal terms, in the absence of agreement between the parties, the court has regard to the terms of the current tenancy. And the major case on it is probably the most important 54 Landlord and Tenant case of all, a case from 1983, House of Lords as they were, a case called O'May and City of London Real Property Company, where Lord Wilberforce in the major judgment had basically said that the starting point is the old lease is the basis of the new lease, and it's up to the person wishing to change the terms to show the fact that the rent might be changed accordingly is not conclusive by any means, and it's got to be fair and reasonable between the parties, but a strong burden to change the terms. In spite of that, in the original case, the WH Smith's case, the court accepted that although WH Smith's hadn't closed during the various lockdowns because they included a post office and post offices remained open, the vast majority of shops in this centre had closed, so the footfall was massively down and their profits were less than 90%. So they thought it was reasonable for the tenant to have that clause, the clause the tenant wanted and not the landlord's, that the rent should be suspended if any premises had to close down and service charge halved. It is only a county court case. To some extent, it depends on its facts that it was a shop, albeit a large WH Smith's in the middle of a big shopping centre. And these things do tend to depend on their facts. The case from early July, the Poundland Toplain case, was a Poundland in Twickenham. Based on the WH Smith's case, they were again going through a renewal. And the tenant wanted a rent suspension provision. They didn't want the rent to be suspended completely, but halved and service charge likewise in the event of lockdowns. And the landlord resisted this. In the Poundland case, the court decided that it wasn't fair and reasonable in relation to the landlord to include a clause that wasn't there in the past. And it would change the whole nature of the commercial relationship. And the tenant couldn't show, the burden being upon the tenant, that there was good reasons to change the clause, even though that is a clause that you frequently have in modern leases since post-coronavirus lockdowns and likes. It tends to be the norm.
Have there been any other issues with that?
Yeah, there was another thing that the tenants were asking for, which I've seen in leases of late, new leases, and that was that the landlord wouldn't be able to forfeit a clause in the new lease, that the landlord wouldn't be able to forfeit for any breach during any future lockdowns, statutory lockdowns, which obviously was not in the original tenancy agreement. And currently, still until March the 25th next year in England, you can't forfeit for non-payment of rent. And we'll have to see what happens to that. But this was forfeiture generally. And the court decided that would be complete rewriting of the lease, and so they refused to accept that as well.
So, what conclusions can we draw from this?
I mean, it's all very difficult because these are county court decisions and they don't set precedents. And I'm sure one day we'll get an appeal case on this, and then we'll have a bit more knowledge about it. I think all we can conclude is they depend on their individual facts to some extent. The county court judgment in Toplain is not a good one at the moment. It's not a particularly thorough one. But they didn't seem to discuss, the fact that W.H. Smith's was dependent on being in the middle of this shopping centre and the likes. They did say that the difference between the W.H. Smith's case and the Poundland case was that in one, the landlord was accepting some degree of rent suspension in the new lease, albeit much more limited than the tenants. Whereas in the Poundland case, the landlord wasn't accepting anything. So I think the message for landlords is don't accept anything. But I do stress it depends very much on its facts.
Perfect. Well, that's a lovely place to round this off, Richard. Thank you so much for joining me once again on this episode of Unpacking the Case. I hope you've enjoyed it as much as I have.
I certainly have, Hannah.
Good, good. We look forward to seeing you next time on Unpacking the Case.